the night before publication for quote-unquote fact-checking. Those allegations are false, and the New York Times either knew they were false or acted with reckless disregard as to their falsity.
This just in, Justin Baldoni's team has issued a response in opposition to dismiss the New York Times.
Justin Baldoni's lawyer just dropped a bombshell on Blake Lively and her loyal supporters at the New York Times, flipping this lawsuit on its head.
Private text messages and other documents that we've obtained reveal what really happened.
It turns out that being rich and famous doesn't always mean you're untouchable, especially when you've got a legal mastermind like Brian Friedman on your side.
A journalist or media outlet by suing them for defamation or libel.
With the latest shocking details he revealed, it's clear who's really winning this battle.
Wrongly casting them as villains and making them scapegoats for Lively's well-publicized media missteps.
And honestly, the New York Times' deceptive reporting in the ongoing lawsuit involving Justin Baldoni and Blake Lively is at the heart of this explosive case. The media giant took a firm stance against Baldoni, portraying him as the villain of the story, someone responsible for orchestrating a smear campaign to destroy Lively's reputation.
The New York Times published a story titled, "We Can Bury Anyone Inside a Hollywood Smear Machine."
This depiction, as you'd expect, immediately painted Baldoni in a negative light, leaving little room for nuance or the possibility that things might not be as clear-cut as the Times made them appear. But that wasn't all. The New York Times didn't just report the allegations. They actively joined the narrative vouching for the truth of Lively's claims and presenting them as if they had been verified beyond a doubt.
That the Wayfair parties orchestrated a retaliatory campaign to tarnish Lively after she alleged that Baldoni and Heath engaged in misconduct while shooting the film.
In their articles and accompanying videos, the Times painted a picture that Baldoni, along with his colleagues at Wayfair, were the perpetrators of this grand conspiracy against Lively. This portrayal not only misrepresented the facts, but also crossed the line from neutral reporting into something much more sinister. Defamatory territory.
The article and video echoed and compounded the baseless accusations made by Lively and her co-defendants, the Lively parties, about the Wayfair parties and falsely accused them of having waged a smear campaign.
It wasn't until the dust started to settle and the lawsuit took shape that the New York Times began to realize the gravity of its missteps. They knew that if Baldoni didn't step up and take legal action, his lawyer, Brian Friedman, certainly would. This was the tipping point for the paper.
It admittedly based its article and video on its reporter's review of thousands of pages of documents and expressly credited Lively's claims, framing them as having been verified by the New York Times' own investigation.
They acknowledged that without the intervention of Baldoni, his legal team, the situation would have slipped under the radar, with public perception easily swayed by their misleading narrative. The New York Times' realization that they had overstepped led them to start distancing themselves from their own reporting. But at that point, it was too late. The damage was done, and the paper's credibility had already been questioned.
Baldoni saying, hey, it just wasn't fair. And we're going to get into the part where Brian Friedman argues, you gave us a couple hours to respond. We scrambled, and you still published it before we could even get our response to you.
Friedman wasted no time in highlighting these mistakes. He emphasized that the New York Times didn't just act recklessly. It actively participated in the defamation of Baldoni character by vouching for the truth of Lively's claims. The Times crossed a line. They were no longer reporting the allegations. They were presenting them as factual. Friedman's argument was clear: the New York Times acted with malicious intent by knowingly presenting false information in the most damaging light possible.
The New York Times prepared its salacious article well before TUI contacted the Wayfair parties the night before publication for quote-unquote fact-checking. After the New York Times' months of plotting with the Lively parties, the Wayfair parties got hours to respond.
This wasn't just careless journalism. It was calculated manipulation. By actively backing Lively's version of events, the Times gave the impression that their investigation had verified the truth of her claims, when in reality, much of what was presented lacked the necessary journalistic rigor to stand up in court. This went far beyond reporting. It was an attempt to shape the narrative to fit a specific agenda.
The New York Times complains of group pleading, claiming it cannot tell the allegations against it from those against its co-conspirators. Of course, it is premature to require the Wayfair parties to specify the acts taken by the New York Times in connection with its scheme with the lively parties.
Now, let's move to the legal battle that's unfolding with Brian Friedman at the forefront, pushing back hard against the New York Times' attempt to dismiss the defamation lawsuit. The Times filed a motion to dismiss, hoping to have the case thrown out before it could gain any real momentum. But Friedman, not one to back down, countered with a strong legal argument. This privilege is a critical shield for media outlets, protecting them when they are simply reporting on matters of public concern.
A jury will determine the truth based on the evidence, but the Wayfair party's allegations are clear. The New York Times argues New York bars 2 California tort claims, but as the Wayfair parties suffered damages in California, where nearly all make their personal and professional homes, they may bring claims under the law of California.
However, as Friedman points out, the Times didn't just report on Lively's claims, they presented them as fact. They took the claims and acted as though they had been substantiated through their own investigation. Friedman's central argument is that the fair report privilege doesn't apply when the media outlet moves beyond simple reporting and starts acting as an advocate for the claims being made by framing Lively's accusations as verifiable truths.
The New York-based New York Times insists it is entitled to New York law no matter where their harm was felt. But California law remedies harms suffered in California by California residents.
The Times removed any protection they might have had under this privilege. This isn't just a small oversight. It's a serious breach of journalistic ethics. Friedman's team is pushing hard to make sure the Times is held accountable for their actions.
Under either California or New York law, the Wayfair parties have stated a claim for defamation against the New York Times, even under the actual malice standard. The New York Times contends that the article and video merely reported facts, and thus the New York Times is shielded by the fair report privilege.
Arguing that when a media outlet has the power to shape public perception, they also have the responsibility to get things right, especially when lives and careers are on the line.
But they argue your defamatory statements affect my client specifically in California. And you know, this modern world we live in with the internet really makes it that you're damaged no matter where the defamation takes place.
The Wayfair parties, including Baldoni, have pushed for California law to be applied instead of New York law, arguing that the defamation and harm they suffered occurred in California. This move is a strategic maneuver, one that aims to shift the legal landscape in favor of the Wayfair parties, particularly Baldoni, who calls California home.
The New York Times has long presumed itself beyond accountability. Not here. The New York Times went past merely reporting on plaintiff Blake Lively's California Civil Rights Department complaint.
California law, known for being more protective of individuals' rights and defamation and false light cases, presents a stark contrast to New York's legal framework. California law allows for broader protections against defamatory statements, especially in the context of false light claims, which can be particularly important for public figures like Baldoni.
And actively vouched for the veracity of its false narrative. The fair report privilege the New York Times seeks to hide behind does not protect it from liability.
Under California law, a defendant can be found liable for placing someone in a false light if the publication of false or misleading statements creates a distorted image of that person. This legal provision could have significant ramifications for Baldoni's case, as it provides him with a more robust avenue for pursuing damages and holding the New York Times accountable for its actions.